Hello everyone, in today's video I will discuss with you legal GK with legal current affairs 2022 and I hope all these points will help you in your upcoming examination. So let's start. First point is relating to 102nd Constitutional Amendment Act and then Maratha Quota, and then after that 105th Constitutional Amendment Act. All these three are connected. 102nd Constitutional Amendment Act 2018 inserted new article 338B and Article 342A. Article 338B deals with the structure, duties and powers of the National Commission for Backward Classes, and now the National Commission for the Backward Classes is given the constitutional status, and now it is a constitutional body. Before 2018 it was not a constitutional body, rather it was a statutory body only. Article 342A deals with the power of the President of India to notify a particular caste as a socially and educationally backward class, and the power of the Parliament to change the list. So in 102nd Constitutional Amendment, first point is that National Commission for Backward Classes is given the constitutional status, and power of the President to notify the socially and educationally backward classes was reserved. National Commission for Backward Classes is a body set up under National Commission for Backward Classes Act 1993. So it was a statutory body, but now it is a constitutional body under Article 338B. And the current chairperson of National Commission for Backward Classes is Bhagwan Lal Sahni, and the first chairman of this commission was Kaka Kalelkar. In 2021, a landmark judgment came, Dr. Jayashree Lakshman Rao Patil versus CM and others. In this case, which is famously called Maratha Quota Reservation case, in this case, Supreme Court held that Maratha Quota Reservation is unconstitutional because it exceeds the limit of the 50% which was laid down in Indira Sahni case, Mandal Commission case. In this case, Supreme Court held that only the President has the power to notify a particular caste as a socially and educationally backward class, and the state has lost their power to identify backward classes under their territory after the 102nd Amendment. So this was the majority decision. But after this judgment, 105th Constitutional Amendment Act came in 2021, which is also 127th Constitutional Amendment Bill. In this, by this amendment, legislation has restored the power of the state government to identify and specify the socially and educationally backward classes, and now state government can also maintain the list of socially and educationally backward classes in order to give them reservation. And by this amendment of 105th Constitutional Amendment, now the proviso has been inserted to the Article 338B. It has also amended the Article 342A and 366 subclause 26C. This was enforced from 5th August 2021. These points are actually very important because for the law entrance examination, for the judiciary examination and all legal examinations this year. Next point is related to writs under the constitutional law. In case of violation of fundamental right to file the writ petition before the Supreme Court and the High Court, jurisdiction of Supreme Court is given under Article 32 of the Constitution, and of High Court is given under Article 226. So writ is filed whenever there is a violation of the fundamental right, and before Supreme Court it can be filed under Article 32, and before High Court it can be filed under Article 226. Right to constitutional remedies under Article 32, right to file the writ before the Supreme Court, is also a fundamental right under Part 3rd of the Constitution. Total writs under Constitution are 5 in numbers, that is habeas corpus, mandamus, prohibition, certiorari, quo warranto. And bulwark of individual liberty is called habeas corpus. Writ of India are borrowed from the English law. So this concept in India was borrowed from the English law, where they are known as prerogative writs. Next important point is relating to Comptroller and Auditor General of India. In April 2021, India's CAG GC Murmu chosen as an external auditor by the Organization for Prohibition of Chemical Weapons for 3 years. This is the current affair point. And current Comptroller and Auditor General of India is G.C. Murmu. First Comptroller and Auditor General of India was V.N. Rao. Article 148 and Article 149 broadly deals with the Comptroller and Auditor General of India's appointment, oath, condition of service, duties and powers. Next important point is relating to the Supreme Court of India. So these are several pointers. Supreme Court of India was established on 26 January 1950. Supreme Court of Judicature at Fort William in Calcutta, which is now Kolkata, was founded in 1774 by the Regulating Act of 1773. This point is also important. Justice N.V. Ramana, who is the current CJI of India, he took oath as the new Chief Justice of India on April 24th and he is 48th CJI. So this is also very important point. First CJI of India, first Chief Justice of India was Hiralal J. Kania. And first Chief Justice of India before independence, when the Supreme Court of Judicature at Fort William was established, then first Chief Justice of India was Sir Maurice Goyer. First female judge in the Supreme Court of India was M. Fatima Bibi. Appointment of Supreme Court judges is done by the Collegium in consultation with the President, and this is provided under Article 124 of Constitution. Judges of the Supreme Court and also of the High Court can be removed from his position by the President only on the ground of proved misbehavior or incapacity. So this is the ground of removal of the Supreme Court and High Court judges: proved misbehavior or incapacity. Then 99th Amendment Act 2014 formed a National Judicial Appointment Commission. This was declared under unconstitutional in the case of Supreme Court Advocate Bar Association versus Union of India 2015. 99th Amendment से जो NJAC Commission आया था regarding the appointment of the Supreme Court judges, that was later declared unconstitutional in Supreme Court Advocate Bar Association case. Next point is relating to the High Court. So there are a total 25 High Courts in India. Court of Judicature at Allahabad is the biggest High Court in India. Calcutta High Court is the oldest High Court in India. Sikkim High Court is the smallest High Court in India. The newest High Court are the Telangana High Court in Hyderabad and the Andhra Pradesh High Court in Amravati. Both are established in the year 2019. And the Calcutta High Court was established on 1st July 1862. Next important point is relating to the important days. December 6 is regarded as the Mahaparinirvan Divas, which is marked as the death anniversary of Dr. B.R. Ambedkar, who was the chief architect of Indian Constitution. He was also the first law minister of independent India. So Mahaparinirvan Divas celebrated on 6th December. Then next National Legal Services Day is observed on 9 November. That is also called National Legal Aid Day, and it is observed every year by the all legal services authorities to commemorate the enactment of the National Legal Services Authorities Act 1987. Next point is relating to the current affairs. Tamil Nadu CM M.K. Stalin made an announcement in the assembly that the birth anniversary of B.R. Ambedkar, that is 14 April, will be observed as Samatwa Nal, that is Equality Day in Tamil Nadu. So you can remember April 14 as an Article 14 because Article 14 is relating to the right to equality. So Equality Day is celebrated on April 14. That is the birth anniversary of B.R. Ambedkar. Next point, November 26 is observed as Constitution Day or Samvidhan Divas every year, which commemorates the adoption of the Constitution of India on November 26, 1949, and the Constitution was adopted and it was adopted on 26 November 1949 and it came into effect on 26 January 1950. So because it was adopted on 26 November 1949, that's why the 26th November is observed as Constitution Day or Samvidhan Divas. Next, World Day of Social Justice is observed on February 20 every year. Next points are relating to the maxims. Pro bono publico means for the public good. This is relating to the public interest litigation in India. Nemo debit bis vexare prona et idem causa means nobody should be vexed for the same act twice, and this is relating to the double jeopardy under Article 20 subclause 2 of Indian Constitution. Next is odi ultram partem, which means no one shall be condemned unheard, and this is relating to the natural justice. Next is nemo judex in causa sua, which means no one shall be a judge in his own case. This is also relating to the principles of natural justice. Next is pacta sunt servanda, that is relating to the international law, which means agreement must be kept. Next is ex equo et bono means according to the right and good. This is also relating to the international law. Next is actus non facitrium nisi mens rea. It means that there cannot be a crime without a criminal mind, and this is very important legal maxim of the criminal law. Next is actus curi neminem gravabit, which means that an act of the court shall prejudice no one. Next is salus populi suprema lex, which means welfare of the people should be the supreme law. Next is qui facit per alium facit per se, which means that he who does an act through another is deemed in law to have done it himself, and this is relating to the vicarious liability. Next is locus standi, the right or the capacity to bring an action or to appear in a court. Next point is relating to some important appointment made, and this is relating to the legal current affairs. First is former Supreme Court Judge Justice Arun Mishra is appointed as the National Human Rights Commission Chairman. Former Supreme Court Judge and one of the India's foremost legal luminary, Justice retired Indu Malhotra, has been appointed as new Ombudsman cum Ethics Officer of Delhi and District Cricket Association, that is DDCA. A former judge of the Supreme Court, Justice Ashok Bhushan, has been appointed as the chairperson of National Company Law Appellate Tribunal NCLAT, and Justice Ramalingam Sudhakar, former Chief Justice of Manipur High Court, has been appointed as the President of National Company Law Tribunal NCLT. So you have to learn, you have to remember the name of both the judges is important. Justice Ashok Bhushan, Chairman of NCLAT, and Justice Ramalingam Sudhakar, Chairman of NCLT. Current strength of Supreme Court is 34. 9 new judges were appointed, including the 3 women were Justice Bela and Trivedi, Justice Hima Kohli, and Justice B.V. Nagaratnam. And very recently, 2 other new Supreme Court judges are also appointed. Justice Sudhanshu Dhulia, he was the former Chief Justice of Guwahati High Court, and Justice Jamshed Burjor Pardiwala, a former judge of the Gujarat High Court. So now current strength of Supreme Court becomes 34. Next important point is relating to the commissions in India. The first law commission was established in 1834 under the Charter Act of 1833 under the chairmanship of Lord Macaulay. The Government of India, next point is the Government of India established the first law commission of independent India in 1955 with the then Attorney General of India, Mr. M.C. Talwar, as its chairman. So you have to remember the difference of both these two. First Law Commission before independence was in 1834. Chairman was Lord Macaulay, and after independence, First Law Commission was 1955, and its chairman was M.C. Talwar. The chairman of 21st Law Commission was Justice Balbir Singh Chauhan. Next commission is National Commission for Women. The first commission, National Commission for Women, was constituted on 31st January 1992 with Mrs. Jayanti Patnaik as its chairman. So first chairman of National Commission for Women was Mrs. Jayanti Patnaik, and the current chairperson of National Commission for Women is Ms. Rekha Sharma, who assumed the charge of chairperson on 7th August 2018. Next commission is the Scheduled Caste. National Commission for Scheduled Caste, and the current chairperson is Shri Vijay Sampla, and the first chairperson of National Commission for Scheduled Caste was Suraj Bhan. Some landmark recent judgments. National Commission for Scheduled Caste. National Commission for Scheduled Caste, Scheduled Tribes chairman is Harsh Chauhan, and first National Commission for Scheduled Tribe Commission was constituted in 2004 with Kunwar Singh as its chairman. So first chairman of National Commission for ST was Kunwar Singh, and the current chairman is Harsh Chauhan. Now the landmark recent judgment, which are very important to remember the name of the judgment and the topic to which it is related. Union of India versus Rajendra Shah and others 2021. In this case, Supreme Court upheld a 2013 judgment of Gujarat High Court which struck down the provision of the Constitution 97th Amendment Act 2021 to the extent it introduced Part 9B in the Constitution to deal with cooperative societies. So Rajendra Shah judgment is related to 97th Constitutional Amendment 2018, which is related to cooperative societies. Next important judgment name is the State of Haryana versus Rajkumar alias Bittu. 2021 Supreme Court observed that the power of the governor under Article 161 of the Constitution to commute the sentence or to pardon will override the restriction imposed under Section 433A of CRPC. And after this judgment, in this case, Supreme Court held that the constitutional power of the governor to grant pardon under Article 161 will override the power given under Section 433A of CRPC. Next important judgment is ML Sharma versus Union of India 2021. Supreme Court discussed the scope of judicial review in matters pertaining to the national security. So this is relating to the Pegasus snooping judgment. Next important judgment name is Kush Kalra versus Union of India 2021. In this case, Supreme Court held that the Supreme Court passed the interim direction permitting the women's candidate to take part in the examination of National Defence Academy. And the landmark judgment of Babita Punia, the Secretary Ministry of Defence versus Babita Punia and others versus 2021. In this case, Supreme Court ordered the grant of permanent commission to women in 10 non-combat service units at 3 months and held them to be eligible to hold command post. It also provides equal opportunity for women in the Indian Army by providing them long-term job security. So this is basically relating to the permanent commission to the women, and this case is also important, Babita Punia case. Next important judgment is Bajranga versus State of MP 2021. In this case, right to property is still a constitutional right under Article 300A of the Constitution. This is held. So this point is also important, that right to property is a constitutional right. Next important judgment is Paramveer Singh Saini versus Baljit Singh. In this case, Supreme Court held regarding the CCTV installation in police station. Next important judgment is Satish Ragde versus State of Maharashtra 2021. This is Bombay High Court judgment, not Supreme Court. In this case, Bombay High Court held that no sexual assault is there if there is no skin to skin contact, and because of this reasoning, there was very much criticism also of this judgment of Bombay High Court. The next important judgment name is Kerala Union of Working Journalists versus Union of India. This is Siddhi Kappan case. In this case, Supreme Court held that fundamental right to life is available to the under trial prisoners as well. And this is the Maratha quota reservation case which I have discussed with you. Supreme Court in this case struck down the Maratha quota as unconstitutional in nature. The 11-member commission headed by the retired Justice N.G. Gaikwad recommended that the Maratha should be given reservation under socially and educationally backward classes, and on the basis of this recommendation, Supreme Court had also granted state government had granted reservation to the Maratha quota exceeding the 50% limit. Then Supreme Court in this case held that Maratha quota reservation is unconstitutional because it exceeds the 50% limit, which was decided in the Indira Sahni judgment of 1992, where the Supreme Court held that 50% of limit for the reservation shall not be exceeded. This can be exceeded only in exceptional and extraordinary situations for bringing the far-flung and remote areas population into the mainstream. Next judgment is Chief Election Commissioner of India versus M.R. Vijay Bhaskar. In this case, Supreme Court held that freedom of media is a sine qua non for democracy. Next judgment is Farjana Batul versus Union of India 2022. In this case, Supreme Court held that professional education is not included under the fundamental right. So professional education is not a fundamental right guaranteed by the Constitution, but it is the directive principle of state policy. It is a part of DPSP, and state has an affirmative obligation to facilitate access to education at all levels. Next important judgment is Anuradha Bhasin versus Union of India 2020. This is relating to the right to internet access. Next judgment is Swapnil Tripathi versus Supreme Court of India 2018, which has ruled in favor of opening up of apex courts through live streaming. Next judgment is Vinita Sharma versus Rakesh Sharma 2020. In this case, Supreme Court held that daughter is a co-partner. Daughter is a part of Hindu co-partnership by birth, like that of a son. So it protects the right to equality of women in the Hindu co-partnership. Next judgment name, which is very landmark, Justice K.S. Puttaswamy, retired justice versus Union of India 2017. In this case, the 9-judge bench had held that right to privacy is a part of right to life and personal liberty. Next judgment is Shebrulu Leela Prasad Rao versus State of Andhra Pradesh and others 2020. In this case, Supreme Court held that 100% reservation given to the scheduled tribe candidate, out of whom 33.1% shall be the women, for the post of the teacher in the school of scheduled areas in state of Andhra Pradesh is not constitutionally valid. So 100% reservation cannot be given to the ST community. Next is Muhammad Salimullah versus Union of India 2021. In this case, Supreme Court rejected the Rohingya refugees' constitutional right to remain in India and allow their deportation by the government of India following the legal procedure. And Supreme Court held that the fundamental right to reside and settle in this country is guaranteed only to the Indian citizens under Article 19, Subclause 1, Subclause E of the Indian Constitution. So this was the last point. I hope this video will help you. So thanks for watching. If you want the PDF of this video, then comment in the comment section. Subscribe this channel for more such relevant updates in future.